Hello, everyone. I think it is not too late to say Happy New Year and good evening for all who are tuning in from Indonesia time, and good afternoon for everyone tuning in from the CED. First of all, I would like to extend my warm welcome to all of the participants for joining this launching of LSA Indonesia Network and the webinar Get to Know about Socio-Legal Studies. My name is Vidya Tuskian. I'm the founder and director of this initiative. Also, I would like to express my gratitude to the speakers today who are also the supervisory board of this initiative, Professor Adrian Bettler and Professor Sulistiawati Irianto, for partaking in today's discussion. And for sure, thanks to my colleagues, the board member of LSA-id, Bari Irawan, the Secretary General, and Bushra Dursun, the advisor, who helped me to make this event happen. Well, I'm actually quite a bit hesitant to call today's event as a webinar because it sounds very formal to me. I would like this event and the upcoming event that we will make be casual, be amicable platform for discussion, sharing, and most importantly, be platform of dialogue, not a monologue. Anyway, before we jump into the lectures, I want to explain a bit about LSA Indonesia Network and the idea behind this initiative. So the LSA-id is an initiative that wants to introduce socio-legal studies to the young legal scholars and practitioners in Indonesia, the millennial, the Gen Z, and much earlier generation. Thereby, actually, I'm quite thrilled looking at the list of the attendee today, well, beside most of the names I already knew, but also most of the list of attendee are the legal scholars and young practitioners coming from various public and private institutions in Indonesia. So it's pretty much fulfilled the target of this initiative, actually. So this platform aims to mainstream an interdisciplinary approach to law that commonly termed as law and society or socio-legal studies, and encourage inclusivity in this discipline. The further detail about what socio-legal study is will be elaborated more by our speaker in more comprehensive and sophisticated manner for sure. But if I could give a brief description about socio-legal studies is a discipline that wants to analyze the law in the book and law in action. So in other words, how the law operationalized in the practical world. One of the central questions of socio-legal is how the law is constructed by society and how the society is constructed by the law. So this discipline is actually quite thought-provoking and naturally stimulates the critical thinking. And we believe that critical thinking is an indispensable quality for the young jurists, as we have to continuously contemplate about the evolving idea of justice to ideally help the development based on each our roles. Socio-legal asks us to reflect that there is something beyond the black letter law, and although the law is authoritative, we really cannot see the law as one pill that can cure everything. That is why socio-legal discuss issues such as access to justice, ADR, legal mobilization, politics in lawmaking process, and etc. To see the power play in the law implementation. But indeed, so like I said earlier, that the law cannot be cured, cannot be pill that can cure everything. It is still an authoritative, and at the end, we cannot discount the role of the law in shaping human relations, the society, as the law provides cultural categories which define the relations between people. That is why socio-legal take a look at it very carefully. Okay, I want to end my speech here so we can proceed to much interesting discussion. So before we start our sessions, I want to explain the agenda for today quickly. The next session will be a keynote speaker by Professor Sulistiawati Irianto, followed by a public lecturer by Professor Adrian Bettler. And after that, we will be having a discussion session. Well, we don't want to call it as a Q&A because not only you can pose a question, but you can also share your opinion or share anything that you like. At the final session, I will introduce you our website and our board member, and after that, we will wrap up our evening. Anyway, this event will be conducted in mixed languages, English and Indonesia. So don't feel hesitant to ask in any language that you feel comfortable in English or in Bahasa Indonesia, or maybe in Dutch. Adrian and Ibu Sulis can facilitate that for sure, but you will need a translator for myself. But yeah, if there is any words or terminology that you don't understand, please don't hesitate to interrupt us to ask. We don't want anyone be lost in translation here. So we proceed to the next session. Sesi selanjutnya adalah keynote speech dari Ibu Profesor Sulistiawati Rianto. Waktu dan tempat saya persilahkan.
Thank you, Widya. Good evening, everyone. Thank you for inviting me to this event, Widya. I said yes when you invited me without thinking. It's because of you. Yeah, this event actually addressed for young legal scholars, Indonesian young legal scholar. So please allow me to use mixed languages. Now, please let me share my. Oh, nggak bisa ini, nggak bisa share. Sorry. Nggak bisa, ya. I would present enriching study of law with socio-legal studies or socio-legal research. This cover of book, I think this is the first book translated in Bahasa Indonesia on kajian socio-legal. It was, I don't know how many years ago. We did it together with Professor Adrian, Professor Yan Hill Otto, and Tricia Diah Wirastri. Ya, ini banyak misunderstanding dari social legal studies di kalangan para terutama legal scholars di Indonesia. Jadi saya mesti jelaskan itu. Kemudian mengapa pengajaran tentang hukum membutuhkan pemikiran yang lebih terbuka terhadap interdisciplinary studies, lalu juga bagaimana socio-legal method berkontribusi terhadap pengayaan di dalam studi hukum dan juga praktik-praktiknya. Ya. Misunderstanding itu dalam hal apa? Banyak orang bilang socio-legal studies itu rumahnya bukan di fakultas hukum. Dan itu sudah lama sekali terjadi dan itu membuat kami harus melakukan semacam untuk convincing mereka bahwa itu tidak benar gitu ya. Nanti saya akan jelaskan mengapa itu tidak benar. Dan kemudian juga socio-legal studies sampai hari ini banyak orang bilang itu sociology of law atau bahkan ada satu school of thought sociological jurisprudence yang disama-samakan dengan socio-legal studies, bahkan juga disama-samakan dengan anthropology of law. Lalu juga banyak yang mengatakan, mahasiswa saya mengatakan, socio-legal studies itu empirical studies. Jadi itu adalah social sciences, bukan study of law gitu. Banyak sekali yang mengatakan ini ya. Lalu juga sebenarnya kita bisa lihat bahwa socio-legal researcher, socio-legal scholars itu berbicara membahas tentang legal instrument, melakukan studi dokumen karena mereka membahas pasal-pasal di dalam konstitusi sampai peraturan-peraturan di tingkat bawah, berbagai macam kebijakan itu mereka bahas gitu. Bukankah mereka juga sebenarnya melakukan doctrinal study ya dalam hal ini, dan mereka melakukan kajian secara kritikal bagaimana pasal-pasal itu saling inkonsisten satu sama lain, incoherent, lalu juga bagaimana pasal-pasal itu tidak masuk akal karena memberikan dampak yang tidak adil bagi sebagian kalangan ya, atau terutama adalah mereka yang berada di dalam kelompok-kelompok marginal gitu. Tetapi socio-legal scholar itu tidak selesai dengan hanya melakukan studi dokumen. Mereka mau pergi lebih jauh untuk menginvestigasi bagaimana hukum itu bekerja di dalam masyarakat. Nah, saya selalu membela socio-legal studies ini, tempatnya adalah di dalam bidang hukum dengan menunjukkan bagaimana epistemologi hukum itu, gitu ya. Bukankah studi hukum itu ada dua ranahnya? Ranah yang pertama tentu saja adalah studi dogma, ya, yang mereka sebut sebagai legal basic knowledge. Tentu saja mereka berbicara soal bagaimana hukum sebagai norma, lalu bagaimana hukum itu mengatur tentang apa yang boleh dan tidak boleh. Tujuannya adalah untuk memproteksi warga negara dari tindakan kejahatan, keserakahan, dan juga memastikan distribusi keadilan. Jadi legal text itu tujuannya sangat baik gitu ya, dan di situ ada ideal-ideal yang ada kalangan juga mengatakan kalau hukum sudah dibuat pasti di situ ada moral-moral yang baik begitu ya. Itulah yang sebenarnya dipelajari oleh para sarjana hukum. Jadi kalau mereka lulus dari fakultas hukum, maka mereka harus punya knowledge tentang criminal law, civil law, procedural law, itu sudah pasti. Tetapi belajar hukum secara demikian baik sekali, tetapi tidak lengkap, tidak sempurna. Gitu. Jadi seorang sarjana hukum seharusnya belajar juga tentang second domain dari law studies ini, yaitu studi tentang bagaimana hukum di dalam kenyataannya. Mengapa begitu? Ini ada Cicero ya, di abad berapa itu, sudah lama sekali, yang adagiumnya sangat terkenal, ubi societas ibi ius, di mana ada masyarakat, di situ pasti ada hukum. Kalau ada dua orang saja bertemu, di situ langsung ada hukum. Karena dua orang ini menyepakati apa yang boleh dan tidak boleh. Lalu juga studi ini bicara tentang bagaimana implikasi hukum di dalam prakteknya. Bagaimana warga masyarakat, warga komunitas merespon hukum. Apa yang mereka pikirkan, mereka rasakan, mereka harapkan tentang hukum. Itu dipelajari di ranah kedua ini. Tentu saja juga bagaimana hukum itu di dalam bekerjanya tidak bisa dipisahkan dari ranah sosial, kultural, economics, politics, itu udah pasti. Jadi kita membutuhkan ruang-ruang metodologi, ruang-ruang teoritik untuk bisa menjelaskan bagaimana hukum itu bekerja di dalam kelindan, di dalam embeddedness-nya dengan soal-soal di luar hukum. Nah, barangkali kalau boleh diberikan contohnya yang kami lakukan selama bertahun-tahun di bidang studi kami, hukum dan masyarakat, itu ada studi-studi tentang sosiologi hukum sudah pasti, antropologi hukum, lalu juga ada gender and law, dan macam-macam. Itu semua adalah mata kuliah yang bisa diberi payung besar, yaitu Socio-Legal Studies, dan barangkali kalau di Amerika, Law and Society. Kami sendiri di Fakultas Hukum UI memberi namanya hukum masyarakat dan pembangunan, law and society sebenarnya. Mengapa kami butuh socio-legal studies ini sebagai seseorang yang belajar hukum atau kita semua? Karena kita melihat bahwa ilmu pengetahuan di dunia secara global itu kecenderungannya memang interdisiplin, transdisiplin, ya, cross-disciplinary approach. Karena masyarakat berkembang begitu cepat, kebutuhan masyarakat juga berkembang, persoalan-persoalan juga berkembang, sehingga ilmu pengetahuan merespon dengan perubahan-perubahan itu. Kalau kita lihat para pemenang Nobel di dunia itu tidak ada yang monodisiplin, tidak ada, sama sekali tidak ada. Jadi di zaman sekarang ya, jadi tentu saja di dalam ilmu hukum juga ada tantangan tersendiri, bagaimana hukum merespon masyarakat yang berubah begitu cepat, ya. Karena juga temuan-temuan teknologi digital, lalu sains, lalu juga globalisasi hari ini sebelum pandemi ya, ditandai oleh gelombang-gelombang migrasi yang sangat masif. Setiap menit berjuta-juta orang dari satu tempat lain, dan itu semua menjadi berubah. Juga di dalam hukum, globalisasi hukum internasional dengan hukum adat, hukum agama, kebiasaan, kemudian hukum-hukum baru. Jadi hukum, terutama di bidang humanitarian, hukum yang oleh delegasi, terutama negara berkembang, yang sangat keras suaranya, menyuarakan kebutuhan keadilan bagi rakyat. Lalu misalnya konvensi CEDAW, ya. Lalu setelah jadi hukum internasional, di-share lagi ke negara-negara, kemudian melalui ratifikasi menjadi hukum nasional. Jadi dengan demikian terjadi organisasi hukum. Ini keadaannya sekarang. Jadi apakah kita tidak merasa penting untuk merespon perkembangan-perkembangan baru, terutama dalam bidang humanitarian dan soal justice. Apalagi Indonesia yang masyarakatnya itu plural, ya, lalu pluralisme itu selalu saja berkelian dalam berbagai persoalan. Apa saja kita identifikasi ada pluralisme, ya. Tentu juga kita melihat Prof. Adi tentu banyak sekali pengetahuannya tentang berbagai macam program pembangunan hukum di Indonesia, tetapi hari ini kita melihat bagaimana di Indonesia juga tidak sepenuhnya bisa berjalan. Kemudian korupsi masih membutuhkan penjelasan yang tidak bisa dilakukan dengan studi teks saja, tetapi membutuhkan keluar dari studi teks itu. Terakhir, secara akademik sebenarnya teman-teman muda yang belajar hukum di Indonesia itu bisa menggunakan socio-legal research atau socio-legal studies, ya, untuk mendapatkan pembelajaran baik di ranah akademik maupun di ranah praktikal. Jadi empirical data yang kita dapat tentang bagaimana working of law in society itu akan memberikan kita pemahaman tentang how people respond the law, how people create law in their own capacity. Masyarakat itu memiliki kapasitas untuk membuat hukumnya sendiri ketika hukum negara dirasa tidak adil. Jadi mereka bisa. Kemudian juga kalau bicara tentang hukum, kita tidak bisa melupakan tentang bagaimana dispute settlement processes, dispute settlement mechanism yang juga dihidupkan di dalam masyarakat. kasus-kasus yang ada di pengadilan itu puncak dari gunung es. Indonesia misalnya kalau baca penelitian dari Nancy Tanner di Minangkabau atau penelitiannya Ibu Kibet von Beda-Beckman, sengketa-sengketa itu tidak langsung pergi ke pengadilan, sangat sedikit yang pergi ke pengadilan, tapi mereka selesaikan sengketa itu di kedai-kedai kopi, warung-warung kopi, di serambi sekolah, serambi masjid, atau di balai-balai desa gitu. Nah, apakah kita tidak merasa penting untuk itu? Kalau kita di tempat ke literatur yang saya minta mahasiswa baca tentang non-contractual society itu legendaris tahun 60-an. Lalu saya minta mahasiswa saya pergi mengikuti contractual society ke lapangan. Jadi mereka pergi ke pasar, mereka pergi ke masyarakat. Bagaimana masyarakat itu mengkonseptualisasi kontrak? Mereka punya caranya sendiri. Bagaimana kontrak itu, gitu ya? Nah, ini sangat penting untuk melihat bagaimana konsep-konsep besar itu dipersepsikan oleh masyarakat dan dengan konsep-konsep besar ini di dalam dispute settlement ya. Lalu juga secara praktikal social legal studies itu datanya sangat penting untuk program-program legal reform, dan para hakim, jaksa, polisi, lawyers ini penting untuk memikirkan bagaimana legal reform program itu bisa terus diupayakan di Indonesia ya. Saya sering membantu Litbang Mahkamah Agung untuk juga menjelaskan tentang ini semua. Jadi aparat penegak hukum di Indonesia butuh sekali social legal studies. Lalu juga decision making proses tuh untuk ini karena mereka butuh membuat academic assessment atau kita bilang akademik sebelum membuat kebijakan apapun. Kebijakan yang paling kecil sekalipun ya, peraturan pemerintah itu butuh sekali academic assessment, karena kalau tidak bisa dibuat peraturan pemerintah yang sangat buruk. Kami semua sekarang sedang mengalaminya di Universitas Indonesia. Pemerintah dibuat sangat buruk dan kami terdampak oleh karena itu. Gitu. Lalu juga penting untuk memformulasikan di parlemen budget yang responsif terhadap kebutuhan rakyat, terutama mereka yang tergolong di dalam disadvantaged group, underserved community ya, perempuan, orang-orang miskin. Bagaimana budget itu bisa merespon kebutuhan-kebutuhan mereka. Saya kira ini semua sangat sangat menunjukkan kepada kita bahwa pendidikan hukum di Indonesia umumnya kurang lengkap karena tidak memberikan pelajaran yang di dalam epistemologi itu ada basicnya ya, di second domain itu. Saya kira itu, Vidya. Terima kasih.
Terima kasih banyak Bu Sulis atas sharingnya. Mungkin kita akan langsung proceed to the next session, public lecture by Adrian. Adrian, do you want to share the screen?
Yes, I will.
Can you do that?
Yeah, I'm trying. Sebentar. Coba lagi. Ya, itu dia. Oke. Saya akan bicara dalam bahasa Inggris karena memang ada beberapa peserta yang tidak bicara bahasa Indonesia. But I'm mainly talking about the importance of social legal studies for the future of Indonesian law. So I mainly aim my presentation to Indonesian young lawyers, the group that Vidya was describing when she introduced the lecture. First of all, I'm grateful to have been asked to give this presentation. Secondly, a lot of what I will be saying is very closely attached to what Prof. Sulis just presented. So but I will go a bit deeper into some issues, and I will also reflect on developments in the Netherlands and in Europe more broadly. First question, why are social legal studies not more popular in Indonesia? Now, and I think the main answer is that it doesn't make you rich. And that is, I think, something we underestimate, because it also applies to the Netherlands, for instance, where all those students who want to go into the big law firms only want to get high marks, and they choose the subjects which they think will take them to the big law firms, such as commercial law, finance, etc., etc. An interesting development here, and I will say a bit more about it later, is that the big law firms increasingly are increasingly interested in students who have more to offer than just knowledge of commercial law and finance, which they can learn in the law firm, because they can never hit the ground running when they come from law school. So we see a kind of a mismatch there. But in the case of Indonesia, I think it's quite important to see this, and also to see that the social sciences generally are not very popular. It is like medicine, dentistry. It is all these very practical professions which you can exercise in any case, and which will make you a good living. So that's something we need to keep in mind, I think, when we're talking about these issues. Second is people don't know what it is. And certainly in Indonesia, there are quite some misconceptions, and Prof. Sulis mentioned many of them. So there is this idea that there is a contrast between social sciences and law, that social sciences are polluting law, that actually there's no place for social sciences in law, that it's something dangerous. And this is something which is quite typical for Indonesia. There's no such debate in any other country I know of. Of course, there are many countries I don't know, but certainly in the literature it doesn't appear, and that's quite special. And I'll also say something more about that. And that has to do also with the resistance from certain law professors who want to keep this polluting element of social sciences, which they don't quite understand because they don't know anything about it, basically, but they think that there's no place for the social sciences in law. That shows that they're really wrong. They're really misguided in that, because as I will show later in this talk, you can't do law without social sciences, because you need to interpret facts that happen in social reality, and you can better interpret these facts if you have some knowledge of the social sciences. So I think that this resistance is misguided. Now, then a question again, which of these books teaches you more about Indonesian law? So one is Sebastian Pompe's study of the Supreme Court in Indonesia. The other is an introduction to Indonesian law. I think you can learn something about Indonesian law from both of them. I think they're both useful. But if you really want to know how law operates in Indonesia, what law does, how political it has become, then you should read Sebastian Pompe's book, and you should not read the Pengantar Hukum Indonesia. And I think that if you read the Pengantar Hukum Indonesia without also looking at a study like Sebastian Pompe's, it's quite dangerous, because it will give you a misconception of what Indonesian law actually is. Now, what are social legal studies? Well, studies already discussed this. I think it's an umbrella term. I like these umbrellas better than, and I think they're more appropriate to Indonesia than the ones we use in the Netherlands during this time of the year. But it's an umbrella term. It captures a lot of different approaches which are united in that they look at law in different ways. You can do that from an anthropological perspective. You can do that from an interdisciplinary perspective. Using political science and law, or using sociology and a legal doctrinal perspective. So there's all kinds of combinations are possible. So I prefer to see it as a very broad term, and I like that because I think it shows the many faces that law has, and it really helps helps us to understand better what law is and what it does. Now, to start with doctrinal legal studies and to show you, to go a little bit deeper into this difference between law and law as a doctrinal legal approach and social legal studies. So the goal is, I think, understanding and improving the law. It's normative. It's really, it is normative interpretation. It's interpretation of norms, and it is usually aimed to make the law better, improving the law, or to come to a solution in a particular legal case. Now, you can do that through studying legislation, and when you study legislation, the method you use is an analysis using legal principles informed by a common sense understanding of reality. That's what most lawyers do. So you use this common sense understanding of reality. If you have no idea about reality, you can't do law, because you don't understand the facts, you don't understand the language, you can't, if you don't know anything about commerce, you can't understand what a transaction is. So you will have a lot of difficulty in interpreting any norm concerning transactions. Now, importantly, I think, and in Indonesia, actually, doing law is often limited to studying legislation, certainly in law school. This is a crusade I have waged for a long time, where I say, look, when you do law, you should study more sources. You should really look at precedents. You should look at doctrinal writings by legal professors. So there are a number of other sources which should be included, and which make legal interpretation much richer, and which really promote legal certainty and justice, because you can get inspiration for different interpretations. Once again, the method is an analysis of all these legal sources, but then using legal principles, and again informed by common sense understanding of reality. Now, finally, you can do that. So you can see we go from left to right, and we're adding a little bit. We're going from studying legislation to studying law, including more sources. And now we're studying law, including insight from social sciences. This means that you have a better idea, you have a more sophisticated knowledge about reality, which will help you to get to better solutions and to improve the law when you're, for instance, also giving advice on how to change legislation. That's not only something you can do when you take a doctrinal perspective, you really should know something about practice too. And of course, that is the case in Indonesia as well. I mean, when a new law is being drafted, there are always people involved, and often lawyers themselves have experience in a particular field and will use that experience in helping draft the law. When that relies on research, on sociological or political science or whatever research, then of course the result will be more realistic, will be better, will create a better law, a more effective law, and also a more effective and a better decision. I'll show you a little bit more about that in a minute. Now, when we look at social legal studies, we see that the goal is another one. The goal is understanding the relation between law and society. Your goal can be to actually improve the law. And I think most social legal scholars want to improve the law. I, for one thing, really want that. When I wrote my study of the administrative courts in Indonesia. In the end, it was a social legal study. It was partly legal. It was partly an anthropology of the courts. And in the end, I came up with a number of suggestions, both legal, how to change the law on the administrative courts, and also a number of them, how the institution could be changed and improved. So most social legal scholars want to improve the law and want to improve the world, but not all of them. You don't have to do that. I mean, it's not mandatory. It's not like a lawyer who needs to come with a solution for a case or with a proposal for better legislation. However, I think if you want to come up with such proposals, it does make sense to take a social legal perspective. So not limit yourself to doctrinal analysis, but also look at what social sciences have to say. So you study how law is created. You can study how the law is being implemented. You can study how the law influences people's lives. And you can study how people use or don't use the law. Now, these are all fields. There are other ways, but I think these are important ones, the most important ones. And you can also, dispute resolution is also an important topic. But all these things show us and help us to understand why law is made in particular ways, how it works when it's implemented, and there you can, from there on, you can also come with suggestions on how to improve this. When you see what the major obstacles are to implementing a particular law, you can do something. You can suggest something to remove those obstacles, and that can be a legal solution and can be a practical solution. So when we think about access to justice, for instance, when we are talking about a legal solution, you can change the jangka waktu, the statute of limitation. So you can, if you know that people need more time to travel to a court, you can also make sure that they have more time to actually submit their claim. But you can also say, look, we need to do something other. We need to develop a circuit court. So make sure that the court comes to the people and that they don't have to travel so far to go to the court. So it can work, but it can be both legal solutions and it can be more institutional solutions. Now the method, it can be all kinds of things. It can be empirical field work, gathering all kinds of reports, can be historical study. So where did this law come from, which groups were involved, what were the stakeholders, how were the debates structured, etc. But it's also legal doctrinal analysis. So you also need to understand the law. And this is one thing which I find interesting, why I think some of the work, I mean, there are, I think the work done by social legal scholars with a legal background has as an advantage that they understand doctrinal law and they understand who lawyers think. Whereas for anthropologists or for sociologists, this is harder to capture. There are some who manage this in fantastic ways, and as jurists have developed as social scientists as well, I mean, you basically need to study both. But the point I want to make is that legal doctrinal analysis is usually an important part of social legal studies. So it's not something opposed to it, it's part of it. And finally, there's the statistical analysis of data, but I think that is not as important as the other ones I mentioned. Now, there are two debates about what we should do about this with this. And as you can see, I included a picture of the late Professor Marjono, who is interesting, I think, because he's quite well known for having been one of the founders of ABNR, which is a successful commercial law firm. But he was also really supportive of what he called a generalist and a liberal legal education. So one question is: are you trying to in your educational system, are you aiming at educating students, training students as legal professionals. That means as judges or as solicitors, advocaat, pengacara, jaksa, or other such legal professions? Or do you want to have a more generalist training so that people, a majority of law school graduates do not end up in the legal professions? They become government officials, or they work in a firm or whatever. And I think the two need different kinds of educations. And the question is whether you want to, whether you want your legal education in university to be completely aimed at training legal professionals, focusing on procedural law, etc., etc. Professor Marjono clearly was in favor of educating generalists, even if he was a successful advocate himself, a pengacara. Then the next question, do you want a liberal or a legal technical education? So sometimes there is this complaint, you know, law graduates cannot, they don't understand the rules, they don't know how to really make a good legal argument, they don't understand the technicalities. So the focus should be on the legal technical education. The other side is a liberal legal education. And here liberal means that you train lawyers in such a way that they understand the importance of the rule of law, that they understand the role of law more broadly in a political way also and historically, and that they have, for that reason, a better notion of ethics and ethical behavior, and of a kind, perhaps a sense of idealism. And again, here, Boy Marjono has made it clear in his writings that he thought that a legal technical education is in fact less important than the liberal part, because the legal technical part, if you end up in the legal profession, of course you need to have some notion of it, but when you get when you get into a law firm, you will learn that in practice. And that was actually how in the past, in all countries in the world, basically legal education was structured. It was a very generalist approach. It was liberal. The lawyers were supposed to be promoting the rule of law. That was their main task. And the practical side was learned in law firms. In England, for instance, in the UK, we still have this system to some extent, where you can actually first do a liberal arts college, and then you do 1 year of law, and then you enter law school. Same in the United States. So there you see that the generalist and that the liberal part is already taken care of in their training, which is different from lawyers in a country like Germany, France, Italy, or the Netherlands. So there is an inherent tension. So there is a liberal legal education which says you need to go beyond legal skills. Here in the Netherlands, two of my colleagues wrote the study of black letter law has to be firmly embedded in a social and theoretical context that opens up the possibility of a critical outlook on law. And this is a really important point too. I think if you only focus on the legal technical education, you're not teaching your students to think critically. You can only do that by opening their eyes to what's going on in the world and to philosophical insights, but also sociological insights, and to make them understand what the law does, and that they have a responsibility also, and that they must think critically about the law, and they just can't accept it and be like robots, because then they will be replaced by computers anyway, and there will be no future for lawyers anymore at all. So I think this is a key. This is a key quote which captures very well also what currently the trend is in worldwide. I think in Europe, in the United States, and unfortunately also in many other countries in the majority world, in favor of a different kind of legal education, a less one less focused on technical issues. I'll bring in this pyramid, which all Indonesians know, and I'm really happy about it, and I really think it should be preserved in legal education. This is, of course, based on Gustav Rathbouch's writings, who is still one of the greatest legal philosophers, as far as I'm concerned, the world has seen. And who said you should not only look at legal certainty, but also at justice and utility. And if you want to look at those, you really need to do more than just an algorithm which produces an outcome when you put a number of data in it, because you need to really balance these, which is something a computer has great difficulty in doing. Okay, now the interesting thing is that when we look at the Netherlands, we see that contemporary legal research is increasingly interdisciplinary. So we see that there is a lot of, generally, sciences are becoming more interdisciplinary. It's something we can see in my own university, where we really stimulated to work with other faculties as well, and with people from very different disciplinary backgrounds. But we also see it how in the bigger research projects in the law faculty, but also in the teaching, interdisciplinary insights are becoming more important. So law is opening up to other, more increasingly opening up to insights from social sciences. Now, an example I can give is the research on crimmigration, which my colleague Maartje van der Woude at the Van Vollenhoven Institute is conducting together with colleagues in the criminal law department. So what they're looking at is how law is being used actually to criminalize immigration, which until the First World War was something you could just do. You could just migrate. There was not an issue at all. Then states started to make this subject to administrative law, and now it's increasingly, it's made a crime to be somewhere where if you don't have the right passport, you don't have the right documents. And we see the horrible consequences of this in Europe with the pushbacks happening, where actually and this is the socially legal side of the social sciences side of the research. Legally speaking, the border guards are not allowed to do these pushbacks at all. This is really going against human rights law in the European Union, is going against the rights of refugees. Still, it's being done. Now, this should be exposed in a way which combines knowledge about that practice, the social insights, with knowledge of the law. And this resulted 2 days ago to a report of the Consultative Council for Migration to the government in the Netherlands, which actually indicts these practices and says that this should be done differently, and really has created a solid report to back these ideas up. So we see that this is something that is happening. Now, what I do, and this is very briefly the final part of this lecture, is that I will show you some ways in which socio-legal research can be important to legal doctrinal studies. So showing you that the idea that people who speak of pure law are misguided, in the sense that you can't do pure law because it's useless. For one thing, a good example, I think, and this is a case taken from Indonesia, you should be aware of ideas about justice. So unless you only care about legal certainty and you don't care at all about justice in your legal interpretation, you need to know how people think about justice. And a very good example of this, of course, was this case of sandals, these flip-flops that were being stolen by a boy, and where the boy was put to prison. I think it was in Sulawesi. The great thing about this case is that the response and the campaign that was, I think only Indonesians can come up with such brilliant ideas. People sending their flip-flops to the police station who had arrested the boy who had stolen the flip-flop. But this was a typical example where you could see that the defense of the police, yeah, it's against the law, so of course we needed to arrest him, that it makes no sense at all, because there are, of course, you should bring in other factors and other considerations, and the law is open to do that. So ideas about justice and what people think about justice are really important. And certainly and this here I link up with what Socio said, certainly in a country as diverse as Indonesia, where certain measures may be quite just in the eyes of one population group, but very unfair in the eyes of another population group. Another example where we can see that law can't do without social sciences is in the interpretation of legal concepts. So, for instance, there are these open norms in the law, in the best interest of the child, for instance. Now, so you're a pure lawyer and you're studying in your law books and you're looking everywhere and looking in your law books, where is the best interest of the child? You won't find it. You will find ideas about the best interest of the child in psychology. You will find them in anthropology in certain cases. In the social sciences, not in legal texts, not in law books. So if you want to interpret that legal term, you need the help of psychologists, of psychological insights, and of other sciences to be able to do that in a proper way and to make sure that you're not doing something completely wrong. And this is difficult already in itself, but we see in practice that if judges do not pay careful attention to this, that really horrible miscarriages of justice may follow. Next one is, it's important, I think, when you're a lawyer, that you're aware of the effects of the law in reality. For example, increasing the minimum age for marriage. Well, officially the goal is to make sure that people don't marry early. What has happened in practice in Indonesia, the practice is that judges are asked for dispensation. So the number of dispensation cases rose with, I think, 10,000% or something. Stijn van Huis wrote an article about this. The effect is that it's not that it decreases underage marriage. The point is that it simply increases the expenditure of people, because they need to pay money to the court, they have to go there. It is just an extra burden on them. And they will do that, or they won't do it, and then they will marry outside of the registry, and their marriage will not be registered, which may have all kinds of negative consequences later on. So this is a clear example of a well-intended measure where the objectives were right, but where if you knew about the practice and what could be expected, where you could see that this was probably not such a very sensible decision, a sensible legal change to make. Another thing is the importance of adat law, and adat law has been reduced in most legal faculties in Indonesia to a kind of a civil code of adat, which has nothing to do, or very little to do anymore, with how adat law and how law functions in practice. And therefore judges often fail to take into consideration the local rules, which Professor is also mentioned in her introduction. So in the case of Nene Nina, there were research was carried out, which said that the fruits which she had picked from under the tree, that was not contested in the court that she hadn't taken them from the tree, but she had taken them from the ground. That actually that was based on a local rule which said that you're allowed to do that after the harvest, after fruits have been harvested, you can take them. Now, you can argue, you can debate that. You can say, look, that was not true, that was not the case. But the important point is that as a judge, you should be open to these kind of things. You should be aware of local rules, and you should also you should decide whether whether the punishment which you impose, whether where you should take into account these local rules when you decide what kind of punishment to impose, or even to decide whether perhaps this was a full defense in criminal law. So again, if you're not open to that, if you don't know, if you say you don't even know there exists adult law, you don't know there's local rules which are really mandatory, which can explain why people behave in particular ways. If you don't know this, then you are at a big disadvantage from a justice perspective, but also from a utility perspective. And legal certainty is something which we can further discuss. Then finally, the context of a case. A good example is corporal punishment of children. So when you look at Europe, particularly England, Australia, it's been quite normal to whip your children, or to use corporal punishment. There's even a saying in English which says, "Spare the rod and spoil the child." So you're supposed to hit your children. Now, interestingly, what we see is that this has fallen into disuse. You're now no longer supposed to hit your children, to use corporal punishment. But what happens is that sometimes people migrate to the Netherlands, and that then cases are reported to the police of child abuse, which actually are within the context of that family, which are quite normal, which are not actually meant to. I mean, there are cases, of course, which go too far, but just hitting a child once is supposed not to be a problem at all. And there's cases have been reported in the US, in particular, where people were sent to jail for a punishment which they thought was perfectly allowable. Now, then again, law is not the right path to follow. You should address that in different ways. But again, we see how important it is to understand the context of a case, and that hitting a child in one situation is not the same as hitting a child in another situation. There is a cultural context, there is a social context, which is quite important. I could give more examples, but I won't, because I think it's time to wrap up. So my conclusions are, if you want to understand anything about the world and about what law does, social legal studies are indispensable. Sorry for the misspelling. If you're interested, if you're curious, if you want to understand better this unknowable world, how it works, what it does, then you should go for social legal studies and not for legal studies. But the other thing, and this other side, if you want to be rich, if you think that's the most important thing in the world, not to understand it, but just to become rich in it, I think the increasing importance of interdisciplinarity in law, so because of the increasing importance of interdisciplinarity in law, social legal studies will inevitably become more important. And we see this very clearly in the Netherlands, where we also see that law firms, and particularly big law firms, are now showing an increasing interest in students which have been trained in several fields or in social legal studies